Hello, everyone. Welcome. I am attorney Ebony Anafaro, and I'm an immigration attorney based out here in New Jersey. However, I represent clients with immigration law matters in all 50 states and around the world. Today, I want to answer a question that I get often with regards to VAWA cases. If you're joining me and you don't know what VAWA is, VAWA stands for the Violence Against Women Act, which is an immigration benefit that allows individuals, both men and women, to self-petition for a green card on their own based on being the victim of abuse and domestic violence from either a U.S. citizen or a U.S. resident spouse. Other individuals that may qualify for VAWA based on abuse include parents of U.S. citizens who are 21 years or older and children of U.S. citizens or residents who are also victims of abuse. One of the most common questions that I get when I have consultations with VAWA clients and potential clients is whether or not they can stay married and still apply for VAWA. This is a very great question, and there are many different reasons as to why someone would want to know this information. Number one, many victims are afraid to leave their spouse because of their unlawful status. As an undocumented immigrant, I would imagine that there's always this fear of not having status, fear of the possibility of facing deportation. So staying in a marriage, even though they are being abused, may seem like the better option for some people. Now, if you're being abused and you fear for your life, I always recommend getting help and getting out, especially if your life depends on it. Leaving doesn't necessarily mean that you have to divorce your spouse right away. You can be separated and still be married. Also, even if you decide to divorce your abusive spouse, you can still apply for VAWA. Under this benefit, you can self-petition no later than 2 years from when your divorce became final. So if divorce is necessary, you are not counted out from the VAWA process. Another reason why I get this question is because the client or the potential client loves the spouse. They love their spouse despite the abuse. Now, this may sound strange to some of you, but it is more common than you think. It is very common for victims of domestic violence to stay married to their abuser because of love. Now, one thing I never do is judge anyone. A person's decision to stay married is their own. However, like I said earlier, I always encourage my clients to get help and consider their safety when they have to. If you are being abused and you want to stay married to your spouse, you can. You can even continue to have children. People do this all the time. There's no rule that requires you to leave or get divorced in order for you to qualify for VAWA. Staying married is an option. Remember, abuse comes in all different forms. Some VAWA cases are based on physical abuse, and many are not. Some VAWA cases are based on emotional, financial abuse, extreme cruelty. You do not have to prove physical abuse to qualify for a VAWA self-petition. So I hope that this clarifies some concern around staying married to an abusive spouse when it pertains to VAWA applications. Staying with your abuser will not disqualify you from applying. VAWA is a confidential process, and if you are the victim of abuse, you can also apply without your spouse even knowing about it, without their involvement. When preparing your petition, we will use something called a safe address so that all documents and USCIS correspondence will come to an address that is not connected to your spouse. And in most cases, we will use our office. This way, your abusive spouse will not even know that you're seeking this benefit. So if you or someone you know would like to learn more about this immigration benefit, you can click the link in my bio to set up a consultation. You can also call my office to speak with me or a member of my team. Our number is 201-565-0099. And thank you for tuning in.